Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Saul Glazer, a Wisconsin construction lien law expert. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the fabulous Saul Glazer.
Thanks for the introduction. Hi, hope everyone's doing well today. So welcome to the webinar. If you have any questions, you can use the chat box and we'll answer questions at the end. Do not include any names or companies in the questions. Just put the question in and then we'll answer them at the end. Second. So today we're going to talk about construction contract basics, lien and bond rules and exceptions, waiver and release best practices, lien law traps to avoid, and tips on how to get paid faster. And at the end, there'll be a slide on SunRay resources. SunRay is an excellent company, and they're definitely worth working with to help you improve your abilities to get paid timely and perfect lien rights. So everyone should be doing business these days with actual written contracts. I know that sometimes you get pulled onto a job and you end up just having basically a handshake deal. But the problem is a handshake may work 9 times, but the 10th time may be the time where it doesn't work. And if you don't have a contract, then it can lead to a lot of problems. If you have an estimate, proposal, or invoice, technically that can be construed to be a contract. If you send the estimate in and the other side doesn't object to it, and then you do the work, you can argue it's a contract. But if you're going to use an estimate, proposal, or invoice, you should require that the other side sign for it. In terms of how a contract should look, so depending on who you are, if you're a prime contractor, if you're a subcontractor, you may or may not have a lot of leverage in terms of changing the terms, but you should know what they mean. And if you don't know what they mean, you should talk to someone like an attorney like myself to figure out what they do mean. In terms of what you need to be concerned about when you're entering into a contract, and especially nowadays, we're going to start seeing more construction defaults. We're kind of in a different time period than we were over the last few years. I saw it a lot around 2006, 2007, 2008. There was a lot of contractors that defaulted, owners that defaulted, and it's hard to say where things are going. But if tariffs start impacting construction, if we end up having situations where there are a lot of people that are deported because they're not legally in the country, that might influence projects. So we might see some turmoil coming up. And so the first thing you need to be concerned about is whether or not whoever you're supposed to get paid from has the financial wherewithal. If you're a prime contractor, you definitely want to look at financial statements. People can look like they have a lot of money. I've been involved in cases where someone on paper is worth $80 million, but it's a bunch of LLCs, and the LLCs the person's a member, and the membership doesn't allow them to actually liquidate the value of their LLC. So just because someone can have a financial statement that looks robust, it doesn't necessarily mean there's money there. If you're a subcontractor, you just kind of have to understand whether or not the contractor is viable. So definitely have a feel for whether or not the party that you're supposed to get paid for has money. If there's financing involved, make sure that the financing is in place. I've had projects where people think they're going to get financing, they don't. And all of a sudden, I had this project in Burlington, Wisconsin, where people had to build these elevator towers, and they sat there for 2 years, and then to add insult to injury, they never got paid for that part of the construction because the owner didn't have any money, and then they had to tear them down because it was in violation of the city ordinance. So they had to pay for the cost of taking down something they were never paid for in the first place. So financial wherewithal is the most important thing. If you're dealing with out-of-state contractors, you need to know whether or not they have money. And then out-of-state contractors may have provisions that make you end up litigating or arbitrating in a different state, and that can add cost. And also, we'll talk about it later, Wisconsin doesn't have pay if paid, but pay if paid means if the owner doesn't pay, the contractor doesn't pay. And so if you have a pay if paid provision in your contract and you end up getting an arbitration in Ohio, which may allow pay if paid, you're in a situation where all of a sudden, even though Wisconsin prohibits it, you might be forced to be not paid because of a pay if paid provision. Scope is very important. If you have exclusions, you want to make sure you put your exclusions in. A lot of subcontracts will say that your proposal is not part of the contract. So you want to specifically say, yeah, my proposal is a part of the contract to the extent it is. Any kind of limitations, any kind of clarifications you want there. Obviously, you want to know how much time you have, because time is money. If the schedule's bad and you have to accelerate, that's going to cost you more money. Price is a major factor, how you're going to get paid, what you're going to get paid if there's change orders. And then the risk transfer provisions in terms of insurance, what insurance you need to have. You want to make sure you have the right insurance. If you're a contractor and you're subcontracting with someone, you want to make sure they have the right insurance and that you're under a written contract, because some insurance for subcontractors doesn't kick in unless there's a written contract. And then the indemnity provisions. Indemnity provisions can be extremely problematic for people if they're overbroad. So you always want to have your indemnity provisions limited to the extent of your negligent act or omissions, or if you breach the agreement, you don't want something where you say, I'm indemnifying you if it's arising out of my work, no matter what, or in whole or in part. In whole or in part means that if you're 1% negligent and the other person's 99% negligent, you're on the hook for 100%. So you want to know what the indemnity clause looks for. That the indemnity clause can be the worst thing you can sign. And then you also need things like you want to make sure you have a differing site condition clause in case there are changes that are unforeseeable. You want to get paid for those. And in the absence of a differing site condition clause, you're on the hook if you're a subcontractor or a contractor. If you're a subcontractor, you also want to know that you're bound by the prime contract, and if it's a bigger project, you want to look at the prime contract to make sure that there's nothing really bad in the prime contract. So what's better, mediation, arbitration, or litigation? So I always recommend mediation in every case I get involved in. Mediation is non-binding though, so you're going to end up, if you don't settle in mediation, in either arbitration or litigation. And the advantage of mediation is that it's quick, it's fast, you don't spend a bunch of money on lawyers, and you have a third party who understands construction, who can then help learn about both sides. They learn the strengths and the weaknesses of both sides confidentially, put everything together, and try to come up with a compromise that works. And it gets the thing over with, because once you're in the arbitration or litigation, you're starting to spend money on legal fees, and legal fees are not baked into construction pricing. And so as soon as you have to spend money on lawyers, you'll all of a sudden, lost whatever margin you're going to make on a project. So pay when paid clauses, that's what they are in Wisconsin. That means you have to wait to get paid until the owner pays the contractor. If you're a prime contractor, obviously there's no pay when paid clause. It's just going to be whatever the payment terms are with the owner. But pay when paid clauses can be problematic, but they're going to be standard pretty much in all subcontracts, and they're much better than their pay if paid clause, because a pay if paid clause means if the owner doesn't pay the contractor, you don't get paid if you're a subcontractor. But the problem with pay when paid clauses, and I had a case in Cudahy, Wisconsin, where they were building an ice mall rink that never happened. And so there was a pay when paid clause, and it took 2 years to get paid because there was always an argument the owner was going to pay and get financing. It was only until 2 years later, where it was clear that the owner was never going to get financing, that the court said, yeah, enough is enough, and the contractor has to pay all the subcontractors. So lien notices, if you're doing residential work and you're a subcontractor, you have to do an identification notice up front. It has to be done within 60 days. A lot of subcontractors don't realize the identification notice has to go to the owner, and it has to be 2 copies. So if you're doing residential work and it's of any magnitude and you have payment concerns, you should get your lien notices out. And the best practice is to get them out early, but if you're a subcontractor, you have them out within 60 days of when you start work. If you don't get them out within 60 days, and you're still doing work on the project, you can send one out, but then your lien rights are only to the extent of when the owner received the notice. So all the lien rights prior to getting the notice, or all the lien amounts, are not lienable if you don't send it out within the first 60 days. So if you do a lot of residential work and you're concerned about payment, you should get in the habit of finding out who the owner is. You need to know actually who the owner is. Sometimes the owner listed on the contract is not really the true owner, so you want to check. If you're in Dane County, you can check Access Dane. If you're in other parts of the state, there's other websites where you can see who the actual property owner is. If it's a non-residential project, or if you've done your identification notice, or if you're a prime contractor, you can then do a notice of intent to lien if you haven't still gotten paid, and that has to be done 30 days before you do a claim for lien. And a claim for lien has to be done within 6 months of your date of last work. And your date of last work can't be warranty work. It has to be either contract work or punch list work. But it needs to be, you need to file a claim for lien within 6 months of your date of last work in the county. You file the claim for lien in the county where you perform work. If you're into the whole notice of intent claim for lien portion, I recommend that you use a lien service like SunRay to help you do it so you don't mess it up, because it's easy to mess up. You have to have the right names, you have to serve the right ways, and then for a claim for lien, not only you have to file it, but you also have to serve it on the owner within 30 days. And the notice of intent just gets served on the owner of the property. If you're a subcontractor, it doesn't hurt to serve the contractor as well, but it's not necessary. And you also can serve a lending institution if there's financing involved. What's a payment and performance bond? You guys probably don't deal with a lot of work with payments and performance bonds. Those are typically in Wisconsin only seen on larger projects or projects involving municipalities or the state of Wisconsin. A payments and performance bond is basically a guarantee that you'll get paid for the work if a contractor has a payment and performance bond. For the contractor, it means that if the contractor breaches the contract, the surety takes over the contract and finishes out the project for the owner. In that case, the contractor is either as a company or individually members of the company are liable to pay back the surety for whatever the surety has to pay out in terms of payments, or to finish out the project in terms of project costs. In terms of payment bond claims, if you make a payment bond claim, you want to make sure if there's a payment bond on a project, you want to get a copy of the payment bond up front, and you want to look at the payment bond to see what the notice provisions are. And if you're not a direct subcontractor, you have to give notice to the surety early on in the project and to the contractor to know that you're out there. It can be, depending on where you are, it can be within 60 days or 90 days. And then there are notice provisions in the bond itself that say that you have to give notice when you haven't been paid at the end of the project, and you want to follow those within the bond. And then you have to typically you have to file a bond claim where you file a bond claim within 1 year of the date of last work. And lien claims, if you perfect a lien claim, you have to file a lawsuit to foreclose it within 2 years of when you get paid. So the advantage of making a notice of intent to lien or noticing the surety is that it stirs people up, and it typically prompts payment. Probably half the time, if I do a notice of intent, I haven't been paid, it'll prompt payment. And if I don't, then filing the lien claim might prompt payment. But if you just file the lien claim, you don't get paid, it just sits there if you do nothing. So it requires you to actually file a lawsuit. And if you provide notice to the surety and the surety does nothing, you actually have to file a lawsuit to enforce the payment bond. So giving the notice of intent or making a claim with the surety, about half the time will prompt payment if there's money to be had. And so it's a good measure, even if you don't intend to actually follow through and file a lawsuit in the end. Lien waivers can be very treacherous. So you want to understand what a lien waiver is. A lot of times lien waivers also include a release of claims, and you never want to sign a release of claims on a project because you might have outstanding claims. So You want to read the lien waiver, see what it says, and if you don't understand it, talk to someone who knows how to understand lien waivers. So if it's just a lien waiver and says, you're waiving your lien rights through the date of your payment application, that's fine. But you also need to understand that if it says for value received or for good and valuable consideration, the day you sign the lien waiver, you waive your lien rights. So you always want to say, this lien waiver is conditioned upon payment in good funds, and if I don't get paid within 10 days, this lien waiver is void. Because if you sign a lien waiver and you don't get paid in Wisconsin, but it says that you've received consideration, it's enforceable even without payment. And you always want to say in a lien waiver that if you have any open change orders, that this doesn't waive lien rights for open change orders, and it doesn't waive lien rights for retainage, and it doesn't waive lien rights for claims that haven't been prosecuted. And a through date means that the lien waiver is through, like if you do it through date of work, you might do it through a payment application. If you do it through date of work, you should do it through, what the amount matches up, because sometimes the lien waiver could be signed 30 days later. And if you do it through the date of the lien waiver, then you waive lien rights for the last 30 days, and that doesn't reflect the payment because the payment is for a payment application from 30 days previously. Sometimes you'll see a request for a sworn statement account. That's going to tell you who your suppliers are, who your subcontractors are, or who your subcontractors are. You're typically required to do that to get paid, but because you're swearing under the penalty of perjury, you want to make sure that everything's accurate, because if you provide false information, then that can be a basis for personal liability. And you also, in Wisconsin, there's a trust fund statute, and if you don't pay people the way you're supposed to, you can be personally liable and actually have to pay triple damages if you're engaged in theft by contractor. So theft by contractor happens if you end up on a project and you get money for a project and don't use it on that project and pay money on it to a different project or for your own purposes. If you're short money and someone doesn't get paid, a subcontractor or the owner can go against you and claim that you should have paid the person, and then it ends up can be triple damages. Also can result in criminal liability. Recently in Wisconsin, we've seen a lot more prosecutors go after contractors for theft by contractor. We want to know whether or not, when you're signing a release, if you're really releasing just lien rights or all claims. A lot of subcontracts will say that when you take final payment, it's a release of all claims you have. So you want to make sure if you've accepted final payments that you have no outstanding claims. And you want to know if the lien right is just a partial lien waiver, or if it's, sometimes we'll say it's waiving the rights for the entire project, and it might be the first lien waiver you sign. So lien waivers can be very dangerous. In terms of getting paid faster, I mean, the best thing to do, again, is make sure that up front you know who you're dealing with, because who you're dealing with is going to make all the difference in the end as to whether or not you're in a position to get paid properly. Typically, if you deliver materials to the site, you're not going to be able to get your materials back if you're not paid. If they're installed, you're not going to be able to take them back. If you hire a lawyer, so legal fees typically are not awarded unless there's a contractual provision. You want to make sure that if you sign a contract, you don't have a one-way legal clause in it where the contractor gets legal fees against you, but you don't get legal fees against the contractor if you're the prevailing party. Generally speaking, I don't put an attorney's fees clause in a contract, but it depends who you are. Sometimes it makes sense. If you're a subcontractor and you're or a small contractor and you're going against the owner, sometimes I'll put a clause in saying, if I have to engage in collection proceedings, I get my legal fees and do it that way, as opposed to a legal fee clause that applies to the entire project. Because once you put that in, a lot of times it ends up just becoming lawyers spending a bunch of money trying to get their legal fees and not resolving the dispute. If you record a lien, you have 2 years to file a lawsuit to foreclose on a lien, and then if you are successful in the lawsuit, then you can have a share of sale, or the owner might pay you off if they lose the lawsuit before you have to foreclose on the lien. If you send a notice of non-payment of surety, they may pay you, they may not, they may ignore you. When a lien is bonded off, it means that a bond is place a lien, and you go against the bond and not the lien claim. All right, so I don't know if you have any questions. I hope you learned something. I guess the big takeaway here is be on guard. I think we are in a changing dynamic right now, and so the most important thing is know who your people are that you're working with, who the owners are on these projects. If it's an out-of-state contractor, you need to be more concerned. Wisconsin contractors tend to be straight ahead. But you always have to stay on top of this stuff, and unfortunately in today's world, one project can be the end of a construction company. And so if you're not getting paid, you got to get on it quickly and aggressively, because if you're first in line, your chance of getting paid may be much greater than if you end up delaying and not pursuing your payment options immediately. So with that,
we do have a question that came. Oh, I do have a question that came through on my end. Can you go back to the question slide for me? Thank you so much. Well, first of all, Saul, you really are incredible. You gave us a lot of great information there. So one of the questions that came up, it says, if tariffs begin mid-project and the costs go up, can you pass along the increase to your customer, or should I have specific language in my contract to account for that?
That's a great question. Yeah, so you want to have, nowadays, if you can get a material price escalation clause in the contract, consensus document makes one. So if you use consensus documents, or you just Google it, you can buy a form, and typically you have to tie it to specific materials. So it's just not for anything. So you'd have to tie it to things that you think are going to be affected by tariffs. I mean, I would assume that lumber is one of them. Steel is going to be one of them. I guess technically windows might end up being caught out if they're coming from China. So yeah, you also can do an allowance in your contract, where you just, if you're concerned about a price, you don't make it a fixed price. So you just say the lumber is going to be an allowance, and so you put an estimate in, and then the actual amount of the lumber cost is going to be whatever it is. And so if you had a lumber allowance for $100,000 and the lumber came in at 110, the contract price would go up by 10,000. If it was 90, the contract price would go down by 10,000. So very good question. And yeah, the consensus documents have a very good material price escalation clause.
All right, perfect. Thank you so much. And then one other question came through. It says, what if I don't have a copy of the full bond, but I was provided the bond number and surety company? Can I still send the bond claim?
Yes, you can, but yes, also the contractor or owner has the obligation to provide you the bond. And so you write to the contractor or owner and say, please provide the bond. Under the Wisconsin statutes, they have to provide a copy of the bond.
Okay, perfect. Thank you so much. That does seem to be the only questions that have come up. If anyone does think of another question that wasn't addressed, please feel free to reach out. We'll be sure to answer any questions for you. Now, can you go on to the next slide?
Sure.
Thank you. Okay, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. As Saul said, it's really, really important to know all the entities that you're dealing with at the beginning. You can download our free project information sheet. It's a really good document to help you kind of get some of the information right when you're first signing that contract, so that way you know who it is that you're dealing with, and kind of help you do some of that research and ask for the documents at that point. So go ahead and check out those resources, scan that QR code. It will be really helpful for you. All right, and then the next slide, please.
Oh, yeah.
All right,
so
our
actually,
webinar
the whole next webinar is going to answer your questions about price escalation and tariffs. Unfortunately, it's not until December. But,
perfect.
But if you check out the consensus document. It's a really, they put it together during COVID, and it's an excellent document that really helps out.
Wonderful. So yes, if you are able to sign up for the next webinar with Saul, that's going to be December 17th. I know that's quite a ways away, but that's okay. That's going to be protecting against price escalation and unavoidable delays in materials. Sign up for free at sunraynotice.com/education. We'd love to be able to see you there. And then the next slide, if you don't mind. Okay, so if you don't mind, give us a minute of your time, give us some feedback through a Google review. We really do appreciate it. It helps us make sure that we're getting the correct content out to you of what you're looking for. And then the next slide, please. That is all we have for you guys today. Thank you so much to everybody who attended.